Welcome to come to the podium, and we're here to hear your argument. Thank you. I trust you're George David Holmes.
Yes, sir. I go by David.
Very good. Mr. Holmes, we are pleased to have you here. I understand you're going to represent yourself, and you're not a licensed attorney, but we're more than glad to have you here, and we look forward to your arguments. As you may have heard earlier, you have a total of 15 minutes to present your argument. You may reserve some of that, up to 5 minutes, for rebuttal to respond to your opposing counsel. Do you wish to save any time?
I'd like to say 5 minutes, and Your Honor, I am a licensed attorney.
Forgive me. Forgive me,
in the state of Tennessee.
Forgive me, Mr. Holmes. I did not realize that.
Well, then, and the state of Arkansas.
Then you are doubly licensed, and we'll give you 5 minutes for rebuttal, and I'll stop talking.
All right, thank you, Your Honor. I'm representing myself in this divorce appeal, and I reserve 5 minutes for rebuttal. This is the first case I've ever appealed, and I've worked my way through it and done the best that I could. On page 25 of the appellate brief, Karen cites the case of Woodward v. Woodward for the proposition that when a trial court has seen and heard witnesses, especially where issues of credibility and weight of oral testimony are involved, considerable deference must be accorded to the trial court's factual findings. And I agree with this point, but I want to point out that Judge Crozier's exposure to this case was very limited. He presided over this case for only 2 days. All Judge Crozier did was preside over the 2-day trial. He took this case over when Judge Thompson recused himself at the first trial. In Karen's proposed findings of fact, page 1260 of the record, volume 9, it states, the court finds that the wife incurred these expenses as a direct result of this court's order and the realtor's list. And I should have started the paragraph before that. The court finds that the wife's out-of-pocket expenses and labor incurred to prepare the marital residence for sale were reasonable and necessary and contributed to the preservation of the marital estate. And then it says the court finds that the wife incurred these expenses as a direct result of the court's order and the realtor's list. Now, this is from wife's proposed findings of fact and conclusions of law. And had Judge Crozier lived through the case, he would have realized this wasn't true. In my brief, I have disproved that, citing to the record. And if Judge Crozier had been involved in the case from the beginning, it never would have made it into the final order. And I did prove it, citing to the brief. I did prove it in my brief, citing to the record. But the thing about it is, Karen knew this too. And attorneys, when they do propose findings of fact, they don't just sign them and mail them, and send them in. They give them to the litigants, and the litigants review them and determine whether they should authorize the judge to sign it, which she apparently did. And this amounts to a false statement. It was not, the wife did not do all these renovations as a direct result of the court order and the realtor's list. A false statement. Okay, then on page, I want to drive home that, and this is cited in my brief. It's on page 211, volume 2. This is the order of the court where the realtor's list was requested by the court, and it was on the 4th day of March, 2019. And the court issued an order as a result of that hearing. And item 4, Fran Marcus shall submit to counsel for both parties a list of all items which must be performed in order for the home to be ready to be listed on or before the close of business on March 15th. And then in parentheses, it states that's 10 days from this hearing. So we're at a hearing on the 4th of March, and the court requests a realtor's list so that we can get this house listed by March 15th. I mean, time's running out. You know, summer's coming. So that's what this realtor's list was all about. So, you know, so what does this mean? Well, it means that any statements or representations made by Karen or for Karen need to be closely scrutinized. But because this was a false statement, and it's big and glaring. The next item I want to talk about is my budget. On the second day of the two-day trial, I submitted a revised budget. It was marked by the court as Exhibit 35. The purpose of this budget is to show my financial outlook over the next 12 years. I was trying to show that I must save in early years to afford to live in the later years. The evidence shows that my income from C&J is due to timber sales and gas royalties. The court should take judicial notice that these items are subject to market fluctuation and are therefore speculative. I could not depend on them completely. In his final decision, Judge Crozier ordered that I pay Karen $18,991.29, and that I not be awarded any money to pay the attorney lien of Sue Dunning. Sue Dunning was my prior attorney, and the amount of her attorney lien was $26,422.70. Well, these are large debts, and they're not provided for in my budget. If you add them together, it's $45,413.99.
Your former spouse here was in the house painting business, is that?
Beg your pardon?
Your former spouse was in the house painting business, is that correct?
Painting, yes.
Yeah. And her business was impacted by COVID, I take it?
Correct.
So does she have this ability to pay any of these expenses?
The expenses the court has in the clerk's office, it's like $117,000. Karen got all of that under the court's order. So that's the source from which this would be paid.
So you, out of that award is where you think that money should come from?
Yes, I do. I think that's incredibly unfair for her, you know, to get all the money under the circumstances of this case. I think to leave me out in the cold like that, it's not fair and equitable. That money should go, some of it to me, so that I can at least start off after this divorce is over, you know, at ground zero. I mean, as you read my brief, I'm entitled to a lot more than that.
So your former practice was in bankruptcy?
Bankruptcy,
Is that
correct.
correct. But you're not practicing bankruptcy law now, is that
No,
correct?
Your Honor.
Because of a disability?
Because of disability, 5 operative reports were in the case.
And so was there any disability insurance involved in this case?
No.
On your practice? No.
No.
So is the primary source of income then the timber business at C&J?
And Social Security.
And Social Security. And that's Social Security disability?
Disability. Well, it turns to Social Security when you turn 65.
Yeah.
I was within a month of turning 66 when the final hearing occurred.
And what was the proof on the amount of the Social Security payments monthly?
It was an exhibit, one of Karen's exhibits that showed, I remember there was a Social Security statement in there, but I think it may have been, you know, it wasn't how much David earns today, but it was unobjected to. I mean,
and what was that amount? What was that amount?
it was a little over $2,000. It's on the budget, and I have that budget over there, but it's you know, in the record. You know, to be fair, I was awarded 10% of the Robin Hood and 50% of the IRAs. But if I sold these, there might be taxes. You know, so it doesn't. It impacts the total sum that the court asked me to pay. But you know, it's a long way from eliminating.
Well, was there some proof put on about what the tax exposure would be if those
No,
assets
there's no
were
proof,
liquidated?
just speculation on my part. So, coming out of the divorce and right up front paying these expenses would be financially devastating for me, you know, given my budget. And I want to emphasize there are a lot of other issues that I haven't covered in this argument, but it's best that the court review that brief and decide those issues. And I was very careful to cite to the record everything I stated in my brief. I cited to the page of the record. This case has been ongoing for almost 9 years. And I noticed, you know, it needs to end. And this morning I was looking for my records. There was a $10,000 mistake that Judge Crozier made. I didn't put that in my brief, and I don't remember exactly what it was, but the court should be careful in reviewing for the $10,000 mistake. I paid Karen $6,080.25 under Judge Wallace's order, and she got $15,000 at mediation.
All right, thank you, Mr. Holmes. We'll hear from you on rebuttal. Good morning.
Good morning, Your Honors. This is my first time to be before you, and I'm honored to be here.
Well, we're glad to have you.
My name is Emily Green of the Robertson County Bar, and I'm here to represent Karen Holmes, the appellee in this matter. And I will just note at the outset, I realize there is a volume of material involved in this case, so at any point that you have any specific questions, I'm happy to go there. It's a lot to cover in 15 minutes, so if you have any specific questions, by all means, please interject and I'll go over that. This is a very lengthy case, as Your Honors are well aware. It started back in 2015, so we're almost 10 years going at this point. There were 15 distinct issues presented by Mr. Holmes in his appellate brief. I think that in general we can distill those down to 3 main issues. One, and these are all outlined in my brief as well, but one being whether the trial court erred in the classification of assets as separate versus marital property. One being whether the trial court erred in division of marital assets, and the final being whether the trial court erred in the division of the marital debts. And I believe, as you will see in my brief, that these are very largely factual conclusions. And I understand that the appellate court gives great deference to trial court's decisions on these facts, unless there's a preponderance of the evidence to the contrary. And our position is that based on the briefs and the information that you will hear today, that Mr. Holmes cannot and has not shown that there is a preponderance of the evidence that the trial court was in error in these factual findings. So with that in mind, I did want to briefly respond to the issues that Mr. Holmes raised, since I know those are on the forefront of your mind. One being the issue of the marital residence. And that was a real property that Mrs. Holmes was residing in that the parties put up for sale. And at the time, the trial court, I'll find it here if you give me just a moment, the trial court ordered that it be sold and ordered specifically, if you'll, on page 11 of my brief, which cites to the court's order, the trial court ordered that the wife shall make arrangements and enter into such contracts as may be necessary to accomplish the items on Fran Marco's list, and that was the realtor. And based on that, Ms. Marco estimated that the house would sell for somewhere in the $280,000 range.
And the house actually topped that, did
It
it not?
did. It exceeded that, thankfully. But as a result of all of the work, I mean, by the court's order, under the gun, my client did have to incur certain expenses. She was a home painter, so she herself did a lot of that type of work, and we submitted all of the itemization for that to the court, and she was awarded reimbursement for that.
I know she did, your client did some work outside, excuse me, painting. Was there any challenge made to the rate that was?
No, Your Honor, there was
Okay.
not. No. Just whether or not it should have happened at all. So the court found, again, that reimbursing her was reasonable, given that it was at the trial court's order that these things take place, at the realtor's recommendation, and if the wife had not done it, then a third party would have had to do it. And there were, in fact, other third party expenses. So I would also note that there was an order agreeing to distribute to the wife the sum of $15,000, and Mr. Holmes made reference of that. But that $15,000 was actually to go towards payment of a credit card where she had been using to fund all of these renovations to the home. So it is not quite fair to say that it was given to her. She did not directly benefit from it. It was the home and the parties jointly that benefited from that. So I just wanted to make mention of that. And I also wanted to make mention as regarding the attorney's fees and all of those issues, that the court actually did not award either party any attorney's fees. That was something that was not awarded to either party, although both in fact did ask for that. And then I would go over just briefly in terms of the finances. The court made a lot of factual findings about the various assets that the parties possessed. And I think it was very specific and exhaustive in looking through all of those findings to determine what was an appropriate division. And in doing so, the court looked at the division of the assets and the debts collectively as a whole to determine, what would be equitable. So I understand Mr. Holmes comes here today and believes that it is inequitable that Mrs. Holmes would receive the bulk of the funds that are still held by the court. But in fact, he's also received benefit of other assets that are in the marriage, and I believe that the trial court was equitable in its division, taking into account those things. So I'm happy to again go through other more specifics and explain anything further. I did not prepare anything detailed just because I did not know where your honors would like to dig into this. But at the end of the day, our position is that this is a very factually driven issue. We believe that the facts in the record very clearly support where the judge's decision came down. We don't actually have any issues on appeal other than just asking for my client's attorney's fees on appeal. But other than that, we believe that the court made the correct decision, and that given that it is all very factual and there's no showing that it is contrary to the preponderance of the evidence, we would ask the court to hold it.
How much marital debt was assessed against the husband? And I understand it was all, and what was the basis for that decision? Certainly.
So of the debt, I'm looking briefly here just to make sure I get the numbers because there are a significant amount. I will come back to the exact number, but as far as why the court assessed some debt against the husband, a lot of the parties' debt was stemming from what we call the Joe Holmes note payable. This was essentially a line of credit that Mr. Holmes accessed against assets that his father held in trust that he's a recipient of, and some.
But that wasn't marital debt. That was just the husband signed that.
Correct. The court held that it was separate debt. It was pledges collateral for separate assets were pledges collateral, so the court did find it was separate. So that was a significant portion of the debt that was at issue. From the time of separation to the time of the actual hearing, it was an additional approximately $210,000 in debt that arose. About $55,000 of that was IRS debt. And I believe you mentioned earlier about innocent spouse application.
Your client did.
That was yeah. Yes, Your Honor, that was this case. So the trial court essentially deferred to the IRS in that designation and did assign about $53,000 to the husband based on the IRS's finding. There were some other credit card debts totaling about $73,000, and some of those were provided for and paid for out of the marital funds that the court did hold. But there are some that were assessed to be paid by Mr. Holmes. And I'm checking here to see if I can put my finger on that total. I do apologize. There's a lot of moving pieces here.
But did the judge state why the debt was assessed against the husband?
Yes. In short, it's a long factual history, but during the parties' marriage, Mr. Holmes was primarily responsible for the parties' finances, and the court did consider that he exerted a great deal of control down to giving Mrs. Holmes an allowance. So his bills, all of his information went to his work rather than coming to the home. So she really did not know what was going on in the parties' finances. And I think that was a significant part of the judge's decision, and as well as looking at who benefited from the debt. A significant portion, as I mentioned, it was around $10,000 the parties had debt-wise, I should say credit card debt-wise, when they separated in 2015. And at the time of trial, it was almost $200,000. And a significant sum of that was related to the husband taking trips to go for medical expenses, things like that, were primarily for his benefit at that time. And some of those were also about $100,000 of that debt was related to his invention, Sunsplisher, which he did testify at trial he intended to monetize after trial. So the court found that it would be equitable for him to incur some of that debt, given that he received the asset and testified of his intent to monetize it. And I think the court was yes.
On this, I'm sorry to interrupt. On the Sunsplisher, I know the briefs pointed out, or at least your brief pointed out, that there was a expectation that husband would monetize that, but there was some assets involved, right? Those were all sold?
Yes, it was essentially.
And was that applied against the outstanding liabilities there, or what
I think it was about $25,000 we estimated in assets, or value, I should say, of the business at the time of trial. So it was accounted for against the debts. Yes. But I think that the court, in looking at the division of marital debt, took all of these things into consideration. And I did also, let me look really quick and just to make sure. I think the court did a good job taking into consideration the purpose of the debt, who was incurring the debt, and the significant control that Mr. Holmes exercised over the party's debt going into this, and his knowledge of that debt to the exclusion of the wife. And I did also want to make mention in terms of the income. I know Mr. Holmes raised some issues about income, and I did have some of those numbers that I wanted to share with the court. Mr. Holmes, at the time of trial, was receiving $2,215 a month in Social Security disability income. He also receives dividends from C&J, which is the stock that he owns a portion of. And those were just dividends averaging out around $2,197 a month. And so he's already looking at almost $5,000 a month in income that he receives on average. And when he reaches full retirement age, his Social Security is anticipated to increase. My client, she did not pay into Social Security. Her sum will be much less. So already, even as we are now with Mr. Holmes not working, he still presently has a greater income than Mrs. Holmes, and his income will continue to go up, whereas Mrs. Holmes will go down. So I think that was another factor in terms of the court looking at the parties' assets and the division of assets, and looking at their capacity for future acquisitions as well, given that Mr. Holmes also will be inheriting from his mother at some point. If the court has no other questions, that's all I had to share with you this morning.
All right, hearing no questions, thank you.
Thank you.
Ms. Green. Mr. Holmes, your rebuttal.
Yes, Your Honor, everything I'm about to tell you is in my brief and cited to the record, except on the Sunsplisher going concern and making money during the course of the divorce. Now, Judge Crozer found that after I moved out of the house, I paid 33 monthly payments on the home. So even though I continued my Sunsplisher, I was making significant payments on the home, and I cite in the record other payments that I made. I cite that it actually came in as an attachment to one of Karen's motions to compel me to do discovery, and there's several paragraphs of all of her expenses that I paid, including everything right down to her cell phone, her car payment, the house insurance, the car insurance, the real estate taxes. So to say that $25,000 that I earned selling Sunsplisher is somehow, it all went into the marriage. We were not finally divorced. until the final hearing. The IRS debt, despite the innocent spouse relief, it was found to be marital. All of the third-party debt was found to be marital, including the IRS. And the Joe Holmes note was found to be marital too. I think she mentioned that, I borrowed it, but it was all marital. She admitted, the attorney admitted in court that it was marital. As far as the house and saying the value went from $288,000 to $307,000, $288,000 was the appraisal of Philip Simpson, an appraiser, and that's in my brief too, cited to an order that recites that. And so that's $19,000. It went up, and she wants $37,000 for doing that. The reality of the situation is she really didn't do it to raise the value of the house. She did it because she wanted to. She locked me out of the house. I proved this in the brief, citing the record. She locked me out of the house. She ignored my text messages not to do all this stuff, these renovations on the house. She borrowed money without court approval, okay? And then over, the court instructed in that same order, March 4th order that I recited, the court instructed to come back to the court if we couldn't agree on the items to do the house. The court told us to come back, and that's all cited in my brief. I didn't go over a lot of the issues in the case, but because I took the time to write them down, and I took the time to cite the record and to make my case in the brief. And I started, and it was just a rehash. I didn't want to get up in front of you and just rehash it and distract from the brief. But there is reimbursement of the house expenses. There's the third-party debts, the credit cards and the IRS, and the third-party debts. And then there's the Joe Holmes note payable that was, as I said, admitted to be a marital debt. I don't have anything else. I think I've rebutted about everything she said, and I've gone to a lot of trouble. This brief was a horrific undertaking for me, and I haven't introduced any new facts. I'm an attorney. I know I can't introduce new facts. I know I've got to stick with the record. I know I've got to prove my case, citing the record, which I did in the brief, and I deserve some relief. And in the final paragraphs of the brief, I indicated what that was. And this is a little bit off the top of my head. I mean, you can read it, but I wanted to put Karen, rather than a specific amount for fixing the house up, I wanted to put Karen, pay her, I felt like I was generous to pay her, well, I'm out of time, but there's a part of the brief where I request, what I request. And I think it's generous. And I just invite you to read that.
All right. Thank you, Mr. Holmes and Ms. Green, for your arguments. We'll take this matter under advisement. That concludes the morning docket.